right. That looks about right. Now we'll just wait another minute or two for other people to log in, and then we'll get rolling. All right, I think that's our usual buffer. Try not to go too long of a delay because it only encourages people to show up later and later. So let us pick up from where we left off. We are in chapter 15 of Yevamot, getting near the end, and we are on Mishnah number 4. And if you were here with the end for last week, we are dealing with a different type of case, which is still going to overlap with Yevamot from time to time. But the general category that we are talking about is the case where somebody is giving testimony about the deceased, about a husband dying, and the implications that that testimony has on his wife, his family, and everyone else. We saw in the previous Mishnayot that if a woman goes off overseas with her husband, and then she alone returns and tells everybody that her husband died, that in general, as long as there aren't extenuating circumstances to make us wonder, that we do believe her singular testimony, which is unusual. This Mishnah is going to pick up on the question of, well, whose testimony do we believe in these cases? And more to the point of this Mishnah, who do we not believe? So let's go ahead and get Mishnah 4 rolling. So all are deemed credible when they come to give testimony with regard to the death of a woman's husband, except for from her mother-in-law, the daughter of her mother-in-law, her rival wife, the wife of her Yavam, and her husband's daughter. That would be her stepdaughter. Make sure we got all of their relations clear, and then we'll talk about why we don't accept their testimony. So her husband's mother, that's her mother-in-law. The daughter of her mother-in-law, that would be her husband's sister or her sister-in-law. And the rival wife, remember, that's what we've talked about, is the other woman that her husband is married to. Polygamy being allowed under certain circumstances in the ancient world. The wife of her Yavam, that would be her husband's brother's wife, assuming that her husband's brother would need to do levirate marriage with her because her husband had no children, and her husband's daughter, her stepdaughter, not her daughter, but from a different or previous wife. So all of those categories are not allowed to bring testimony. Remember, of course, if you have 2 witnesses of normal standing, then yes, they would be allowed to bring testimony, but these are in cases where you have singular evidence for the death of the husband. So why is it? The commentary we have continues. The reason is that these women are likely to hate her and will lie to her detriment. The Mishnah explains, before I get to the Mishnah explaining, it may seem shocking to us to think that the mother-in-law, the sister-in-law from different ways, her rival spouse or her stepdaughter might not like her, but come on, how many movies or books have you seen where that is a major plot point, where there is an unhealthy tension between the wife and other women in the extended family? Unfortunately, this is still something that people often encounter. Not as bad as the jokes and the sitcoms of the 50s and 60s make it sound, but it is still not unlikely or rare for there to be this type of tension. And as we talked about in the first Mishnayot of this chapter, of chapter 15, if she gets married on faulty testimony, then there can still be real world consequences to her, her remarried second husband, and the children that she might have sired with them. So we have to be a little careful about which testimony we allow in from people that are of a category that is known to have tension with a wife. We already talked about in the first Mishnah that if she was known to have tension with her husband, that we might not believe her testimony. Here, we're seeing that other people also could be put off limits because of the tension that is so common in these relationships. Aaron, you have your hand up?
Yes, Rabbi. You said despite the fact that they may have motive to lie, if there were two of them, they would be valid?
So in classical Jewish legal standing, under most normal circumstances, women are not allowed to give testimony at all. That was one of the considerations of the ancient world, which was based upon the unequal social standing of the ancient world, where women were so beholden to their husbands under the economic structure of ancient society, not through Torah, but from just the economics of the day, that the husband could often exert undue influence, or any male in the family that was in control of the estate, undue influence over the women in the estate. So women were not allowed to give testimony under most normal circumstances. Here, however, we're talking about singular people coming in the unique case of the death of a husband, which we are looking for opportunities to be able to confirm it substantially enough that we can free a woman rather than keeping her married to somebody that is dead.
But yeah, no, the question I had though was about the motive though. The motives, even if the motives wouldn't prevent them from testifying too, even if they weren't female.
So here we're not talking about so yes, if you want to talk about in general, then that's true. As long as we do not have credible witness to their deception, as long as we don't have credible testimony that they are lying, or that there is a nefarious plot or purpose to their mistestimony, then people are, under most circumstances, allowed to act as witnesses. If it is very clear that they are the enemy, so for example, if everybody knows that Reuben and Shmuel have been fighting every day of the year for the last year, and Shmuel shows up with another guy, and they've concocted some story that Reuben owes them $5,000 all of a sudden, then yes, that becomes very suspicious under those circumstances. But here we're not talking about the unique vendetta, rivalry, anger, hatred of an individual witness. Here we are talking about a category that is suspect because of the frequency with which there is tension, and that tension overrides the exceptional leniency that has been granted under this set of circumstances to normally accept just one and even a woman's testimony. So this is saying, yes, we generally would allow, we generally wouldn't allow women's testimony at all for the reasons I mentioned earlier. By the way, the conservative movement does allow female testimony in the modern world, but normally we wouldn't allow it, but we do because we want to be able to free the woman from being married to a dead man. However, our leniency in allowing them to testify is going to be limited by our experience with the rivalry that can sometimes happen and the anger within a household. And so we are going to take these people off the table as potential witnesses under this unique circumstance, even if we don't have special evidence that they are antagonistic to one another. If we have special evidence that a regular witness in a regular case is antagonistic, then they can also be disqualified. But that's why this is being so careful to take a group off rather than individuals.
So, Rabbi, in a criminal case, a victim would almost never be able to testify because they would have motive to lie?
Well, in Jewish law, a victim by him or herself, well, himself in the ancient world, would not be sufficient to testify against a person. You would need to have additional witnesses to be able to confirm what they did.
And did you mean sufficient to testify or sufficient to convict?
Well, so yes and no. I mean, the rules of testify and the rules of conviction are pretty much the same. If you have two valid witnesses and no contrary witnesses or additional reason to suspect their testimony, and the two valid witnesses say that XYZ happened, that is considered to be what happened, and that is what the court will decide based upon. There's still room for interpretation of the evidence of their testimony and all of that, but in the ideal world, if you have two witnesses that are not, you cannot find contradictions or flaws within their testimony, that you have no other witnesses that contradict them, their ability to testify is also their ability to convict, if you will. If there is nothing else wrong with what they have been saying as quality testimony.
Right. By ability to testify, I mean their ability to come in front of the court and be one of those witnesses. So
exactly, to be considered as credible. They're not impaired in any other way. They're not known as criminals or other people that have the axe to grind, so to speak, etc.
Yeah.
So just two neutral people come in, and two neutral people give unimpeachable testimony, which cannot be contradicted, which no one believes is false for any other reason. Their testimony is the version of what happened, and that is enough to settle a case.
Right. I thought, but a victim's generally not neutral, and plus, I thought their testimony had to be rebutted by two witnesses. If you did have two neutral witnesses, I thought one could not rebut the testimony of two.
Correct. That is correct. When I say it's unimpeachable, I mean without additional witnesses that come to testify against their testimony. Yes, right. One witness cannot countermand two, which we will get to eventually in our discussion tonight, actually.
And a victim, they're not neutral, but they can still testify, right? Unless you can show animosity before the crime.
Well, yes. I mean, so again, it gets a little bit more nuanced depending upon exactly how the crime took place and what happened, and whether or not there is evidence of bad blood between them prior, and also that they would still need to have additional witnesses to be able to corroborate what they say. That they cannot be the only witness to a crime to be able to convict someone.
Right, but
remember as well, this goes not just for you, because I'm sure you remember, but I'm going to make sure that everybody else who's either attending or watching, the rules for perjury in Jewish law are very different than the American rules for perjury. If it turns out that you have bribed someone else or just gotten together with someone else to give false testimony against a person in the attempt to either convict them or hurt them in a civil case, if it is discovered, then the false witnesses will receive whatever the punishment would have been had their testimony been able to convict or go against the other person. So getting together with someone to say, oh yeah, he beat me up, and therefore he owes me, XYZ in damages, is not a smart plan if you know whatever you're trying to get out of him. If it just comes out that your witness it's not possible for him to have been able to see it, and there's no way that testimony could have been observed, then you and he are going to be in real trouble with regards to the outcome. It's not like a slap on the wrist or 5 days in jail or contempt of court or anything like that. Perjury carries scaling consequences, and the worse the case is, if you're going all the way up to the death penalty, you can actually be executed under Jewish law for lying during a trial. Which personally, I think, well, not the execution part, because it's pretty hard to know that's when that's right and wrong, and we should be very careful about doing it, as our tradition says. But in general, I think that having a scaling system to try and discourage lying to judges and juries would probably help. But I'm not here to make American law. I'm here to help with Jewish law.
But Rabbi, it wouldn't be the penalty for perjury wouldn't be double what you were trying to extract. It wouldn't parallel to theft.
No, it's not. It's you as the Torah says, which is where the rule comes from. as you were trying to do to the victim, meaning the victim of your lies, so will be done to you. So it doesn't scale up, because many types of this type of perjury, edim zomamim, are not trying to extract. Only in monetary cases would that be the case. The Mishnah explains, meaning that we're going to continue this conversation on a slightly different note. In the case of a divorce of all people, including these women, meaning the ones that we started off our Mishnah with, they may bring her bill of divorce and testify that it was written appropriate. What then is the difference between a bill of divorce and death? Right? These women could show up and they could have the get, the divorce document, and they could say that it was written appropriately, and that would be grounds sufficient for a divorce to be concluded. So how is this bringing information about the death different than bringing the information about the death, the difference between the debt and the get in testimony? The Mishnah answers, the difference is that in the case of a bill of divorce, the writing proves the accuracy of the testimony. That is to say, our commentary points out, her testimony is supported by the text of the document itself, whereas with regard to the death of her husband, there is no proof apart from the statement of the woman herself. So although it's not a perfect standard or perfect distinction, an actual get has to be written in certain ways to prove that it is correct and appropriate. And if the document appears by all other measures to be correct and appropriate, including the names of the witnesses who witnessed its writing, then the woman who shows up carrying it, even if she's one of the five, is not really testifying entirely on her own. It is her word plus the document, which has its built-in witnesses and built-in accuracy. So there is a reason to accept her testimony, her delivery for the get, where we wouldn't accept just her word when it comes to the death. All right. Now, if one witness says the man died and the wife married based on his testimony, and one witness came and said he did not die, so one guy shows up and says, hey, your husband died, so sad. And the wife says, well, that's terrible. The investigation shows there's no reason to doubt this. And she goes ahead and she gets remarried to someone else. And then another guy shows up, some months later perhaps, and says, what are you talking about? Mr. Cohen is alive and well and living on Cyprus. In such a case, she does not leave her new husband due to his testimony, meaning the second witness is not strong enough to cancel the first witness's testimony. 1 versus 1, we don't cancel. Even though we would accept one witness to prove a death, which is unusual because normally we want 2 for most issues of Jewish law, we don't accept one witness to overturn that first witness. So even though we make that special exception for allowing one witness to testify for his death, we don't extend that special circumstance for one witness to testify against his death. However, if one witness comes and says the husband died, and 2 witnesses say he did not die, then even though she married based on the first witness, she must leave her new husband. The 2 witnesses now are considered to be sufficient enough testimony to make us feel that the first husband has not died, and therefore she is not allowed to remain married to the second husband, because that would be adultery in that case. If 2 witnesses say he died, and 1 witness says he did not die, the testimony of the 2 witnesses is accepted, and even though she did not yet marry, she may marry. So even though there is a slight differences of opinion between 2 and 1 on the case of whether he died or not, if the 2 say that he died, then she is given permission to go ahead and remarry. Questions on those matters of testimony?
Rabbi, did you say if one testified before she got married, she's prohibited from getting married, right?
If in which case?
The one where you said somebody testified after they got married, they do not make her get divorced. But if they testified before she got married, she's prohibited from getting married, right?
I would have to double check my notes, but hold on a second. It's the trouble with having a brain that sometimes doesn't remember everything you want it to remember. Let me just check what I've got here. Second.
In which Mishnah are we?
We are on Mishnah 4, chapter 15. Right. So, yeah, it gets a little bit more. So if when it says that she is married, it's not specifically about the marriage. It's about whether she has received permission from the court to get married. So if one witness comes up, says that he has died, and the court agrees and says you have permission to get married, then she is permitted to get married, even if the other witness shows up before she has gotten married. Once the court has issued its ruling, then it's done at that point, and in this circumstance, in this way. However, if one witness comes and says that he died, and the other witness comes and says he didn't die before they've rendered their decision to confirm the witness's testimony, then you're right, she is not allowed to get married. So it's not just whether she's been married or not, it's whether or not the court has approved the testimony of that first witness yet or not. All right, let's go ahead then and take a look at Mishnah number 5 from chapter 15. If two women who were married to the same man come forward, and one of them says that the husband died, and the other one says he did not die, the one who says he died may marry on the basis of her own testimony, and she takes the money of her marriage contract, the ketubah. And the one who says he did not die may not marry and does not take the money of her marriage contract. Now, this may sound a little odd. If you're permitting one woman to get remarried because her husband is dead, how could you not permit the other woman to get married because her husband is dead? And this goes to the sort of the heart of the matter of this being a very special case of extenuating circumstances. Because the first woman has said that he has died, and since we have agreed that without any additional reasons to doubt it, we accept the testimony of the wife that her husband is dead so that she can get remarried. And as we established, under such circumstances, she would collect her ketubah. She would take the money owed to her by his estate. Then we let her remarry. But that same logic also tells us that if a woman comes and says that he did not die, then we cannot give her permission to get married, even though we gave it to the first wife. The other wife does not have permission because by her own opinion, her own statement, it is that he is still alive. And since she is not getting remarried, then of course she does not receive her ketubah, meaning if she's not free to remarry, then of course she is not considered to be separated from her husband, and she cannot collect her ketubah. So we can end up with a different ruling between wife 1 and wife 2. Depending upon what each one is claiming. Second half. Aaron, yes, question first before we get to the second half.
Yes, Rabbi. Wasn't part of the issue though that why they can't remarry is because she doesn't believe that her husband's dead, and it would not make sense to let someone remarry while their husband's dead?
Well, exactly. I mean, she by her own mouth has said, my husband's not dead. And so because she has said that, she cannot get remarried. But we're not going to bind the other woman to her statement.
But if, let's say, is there some period of time where she will be able to get married and say maybe the other one was right? Let's say 5 years or 7 years goes by and she still hasn't seen her husband?
Well, no, because if presumably if she said he's not dead, we're not talking about a case where she is just going off of random personal intuition. but that she has not been convinced of his death, or she didn't witness his death more specifically, then if she doesn't think he's dead, then she doesn't have grounds to get remarried. But just because she doesn't think he's dead doesn't mean we hold the other wife back who does think he is dead from whatever witnessing she may have had to his death. Again, obviously, if there was a third party, or rather two third parties, two additional witnesses, then there wouldn't be any doubt in the matter, and both of them would be considered widows, and both of them would receive their ketubah.
But if she hasn't seen her husband in 7 or 8 years, she might start to think maybe he is dead.
She might. Unfortunately, Judaism doesn't really go in for the idea of legally dead based on the absence of a person for a certain amount of time. So
if she's wrong, she could be stuck forever with no husband?
Well, yes, which is why if you're not sure whether the person is dead or not, you probably shouldn't be giving testimony in court. Remember, this isn't just two people sitting around saying, you know, it was a pretty bad storm last night. I wonder if Bob died in the storm out at sea. These are two women who are coming before the court and giving testimony legally about the status of their knowledge of the situation. And the court is doing the best they can with the information that they are being presented with. So it's if you don't know, then you would have to say, I didn't witness his death. I don't know whether he is alive or dead. And if you did witness his death, then it would be best to say, I witnessed his death. Even if, you know, you're still praying that maybe a miracle happened, and when he was hit by the bus, that maybe he just decided to go off and live in Idaho instead. If you saw him die, you saw him die. Does that make sense?
Yeah.
Okay, now Rabbi Meir is going to.
I have a question.
Oh yes, Natan. Sorry, I didn't see your hand.
Try to be polite. Come on. We're talking about the same court. So how could the same court can have such two different verdicts? In one hand, they say, okay, yes, you can remarry because it looks like he's dead. And the other hand, for the same person, the same court say, no, you can't, because not like need to be some consistent from the same court, or they declare that the person is dead or not, but they cannot say, okay, yes and no, depending who the person is coming to us.
Well, but they are being consistent, but the consistency they have is probably not the consistency that you're expecting. So the court is being consistent throughout the first 5 Mishnahs of this chapter, of saying if a woman comes before the court and we have no reason to doubt her integrity or the situation involved, that she and her husband were not enemies and that there wasn't war at the time, like we talked about at the beginning of the Mishnah of this chapter, then we are willing to use different rules of evidence than we normally do. And under most cases, we will take her testimony, even though she's a single voice. So because they're willing to take the single voice of testimony in this special case, the court is almost forced to say, she has said he's dead, and therefore we will not undo her testimony. And the other one, he has not, she has said that he's alive, we will not undo her testimony, but even though their testimony is contradictory.
Yeah, because they are talking about the same subject.
They are.
Rabbi.
Yes. We'll come back to this, but let's get the other question on the table.
Yeah, I thought the other reason that you get contradictory answers is that one sister wife can't testify against another sister wife, or I should say rival wife. One rival wife can't testify against another rival's wife. Therefore, the rival wife who said she is dead would not be valid against the one who thinks he's alive, and the one who says she's alive would not be valid against the one she's dead, since they're rivals, right? Or no?
Right. As far as like when we were talking about in the last Mishnah, where we had the case of one person who said he had died and another who said that he was alive, and could their testimony cancel each other out, even though it's only one person versus one person? You may remember we talked about it as happening before or after the court has made a decision. In this case, we take the first half of that last Mishnah, where, like you point out, the rival wife cannot testify about the status of the other wife and about the status of the husband on behalf of the other wife, because we are worried that they would be acting maliciously, that one of them may be saying what they are saying deliberately to harm the other one. And so their two testimonies, even though they're being accepted, cannot cancel each other out, because they can't speak contradictory to each other. That is to say, a wife cannot be testified, the status of the wife's husband cannot be testified against her by the rival wife. And here we have two rival wives. And so even though it's one versus one, which, like we said in the last one, would normally cancel out if the court had not made a decision, because their testimony is not relevant to each other because of their suspected rivalry, it doesn't work for either of them. And so therefore, the one goes free on her own testimony and the other remains married on her own testimony. And do understand that that could be not at all what either one of them want. Right? One of them might want to stay married, but she saw her husband die, and so she's testifying honestly, and now she is getting her ketubah, and she has to leave the estate, which, depending upon the age of the children, may also mean that she is leaving her children behind. There are many negative repercussions to being freed that might not be what she wants. She could also be married to a very wealthy man, and maybe living on his estate for the rest of her natural life could be a benefit to her, even if he never comes home. But because of her testimony, she is now free, and vice versa. The one who says, I didn't see him die, or I think he is alive, based on my witnessing, she may wish to get remarried. Like you said, it could be that she'll regret the fact that she didn't see the death and therefore is now stuck in this position. But saying what you have seen or not seen honestly is the foundation of how Judaism tries to handle all of its cases, how it tries to adjudicate all of the situations. And so when rules of evidence have been set up, they need to be followed, even if it leads to this paradox of one woman becoming a widow while the other remains married in the absence of the husband.
Hey, Rabbi, did you say you can lose your kids because your husband dies?
It's not losing kids. It's not like American divorce law, although it does happen in that case as well. The children of a man are considered to be his heirs first and foremost. And that means that if the wife is either divorced or if the husband dies, that once the children are considered old enough to be separated from the mother, once they've been weaned at that point, then the children would go to the family. Now, in good and happy relationships, the family would still, of course, want the wife to be around and to help raise the children, provided there wasn't an additional conflict going on or tension. But the standard assumption would be that when her husband dies or she is divorced, she returns to her father's house or her brother's house if her father is no longer alive, and her children remain with her husband's house, either with him if he's still alive in a divorce case, or with his family if he died and she is a widow.
So the children.
Yes, that is surprising to the modern world, where people have a very different notion of custody. I will point out that in the modern world, we do defer custody issues to the civil courts.
So the children would follow the inheritance?
Yes, they follow the line of the father. Which, when you think about the way the inheritance law works and what it represented in the ancient world, made absolute sense. It really was where they needed to be in order to maintain the household line, if you will, that was attached to the land, and by the land, the ability to continue to feed themselves and the next generation. By the way, the fact that, as I'm sure you're beginning to realize, that a widow or divorcee could be then in a pretty bad situation if she doesn't have a good relationship with the husband's family, or if she doesn't have another family member to return to. That is precisely why both the Tanakh as well as rabbinic literature go out of their way to remind us that we need to take care of the widow and others that are in these types of situations, because they don't have the family support structure to look after them. And so it becomes the obligation and the responsibility of the community to take care of them. But to do otherwise, just to make sure that we get the whole point in, is problematic, because to appropriate funds that the Torah has not given us authority to take from a family or from an estate is the equivalent of theft. And in many ways, you'd be stealing from the man's children in order to pay their mother. And that's a little weird. And it is very unusual from the modern point of view, but then the intimate connection between families and the land as the primary form of production and livelihood created a very different model of inheritance rights and family views than we have in the modern world. It shouldn't be too surprising if you've studied any sociology, economics, or politics to realize that the economy of a situation of a community can have rather strong impacts on many of the social behaviors of the people under that system. Second half? Okay. Let me make sure I've got my menu over there, and let's get this up so I don't have to look through the wrong part of my glasses. If one wife says he died in a normal manner, and the other one says he was killed, Rabbi Meir says, since they contradict one another, these women may not marry. So they both agree that he's dead, but they're giving different stories of how he died. And since their stories are different, then we take them as contradictory witnesses, and therefore neither testimony is reliable. That's Rabbi Meir's position.
I agree with Rabbi Meir.
Well, wait, you haven't even heard Rabbi Yehuda and Rabbi Shimon.
Okay.
Rabbi Yehuda and Rabbi Shimon say, since they both agree that he is not alive, they may marry, despite the fact that they dispute the circumstances of his demise. So Rabbi Yehuda and Rabbi Shimon say, look, yes, they are arguing about whether he was killed in a bar fight or whether he died of pneumonia. Yes, that is true. There is an argument there. But if they were arguing about whether he was killed on a Tuesday or whether he was killed on a Wednesday, isn't he still dead? And since the main issue that we are dealing with regards to these women is whether or not they are widows or whether or not they are still married, the fact that they both argue that he is dead means that whichever one might be right, they are both free as widows and no longer considered chained to him. So,
I retract my vote. Now vote for them. Did they win?
Yes, they win. Right, their position is the dominant one.
Okay, great. Yeah, because that doesn't make sense.
Right, exactly. Rabbi Meir is using the normal standards of testimony, where if you have two witnesses who disagree on substantial issues, then their testimony cancels out. But Rabbi Yehuda and Rabbi Shimon are saying, yeah, but the only substantial issue that's important for these women right now is he dead or not? And on that issue, there is agreement. Now, when it comes time to pursuing a murderer or some other way that he might have died that might need additional justice, then yes, their testimony is problematic, and that's something that we'll have to deal with in some other form of investigation. But with regards to their status, there's no argument. They should be allowed to go. Aaron?
Yes, Rabbi. How is it that one's testimony can be used against the other when we just read that they could not be used against the other?
So Rabbi Meir isn't saying that they can be used against each other. He's saying that in general, if you have two witnesses of contradictory testimony that are not trying to dispute the outcome, but are trying to dispute the facts of the case, that makes their testimony flawed and thus unreliable. So that in a general case, if I had two witnesses who said he murdered somebody on Wednesday, and you have two other witnesses who say he murdered somebody on Friday, none of those four witnesses are considered to be valid witnesses because they are missing information of a substantial nature to the actual case. But in this particular case, so that's what his argument is with regarding this rule, that they're not arguing against one another because they both agree he's dead, but that's the testimony they give. Just like in my other example, that if you had 4 witnesses, 2 of whom said one and 2 of whom said a different thing about when a person committed murder, they're not arguing about whether he was a murderer, but their testimony is considered unreliable because of the contradictory nature of it. So too, that's the standard that Rabbi Meir is trying to use here. But like I mentioned, Rabbi Yehuda and Rabbi Shimon are saying, no, they are reliable, at least with regards to his death, and that is the major issue that we are trying to resolve.
Right, but in both issues, I thought one rival wife's testimony in general could not be used against another rival's wife testimony in this situation. And
So I think the issue that you're using, that we're getting hung up on in our understanding together, is it cannot be used against the other wife. Indeed, if one wife said he died and the other one said he didn't die, well, that's the first half of our Mishnah. And then one wife doesn't have to listen to the testimony of the other and vice versa. But here, their testimony is not actually against the other wife, is what Rabbi Yehuda and Rabbi Shimon are saying. That the testimony is, each of them is actually corroborating the other's essential point, which is he's dead.
By against, I thought they meant they couldn't be used in the other's trial. I thought no matter what you said, what each of them said, they could not be used against in each other's trial. Not necessarily against, but it was inadmissible in that trial in general.
So it cannot be used against them in the sense to contradict their conclusion.
Because in the first one, if I think my understanding from the previous Mishnah, that if the wife who said he was dead wanted to go back and make a claim that he was alive, or wanted to use her rival's wife's testimony that her husband was dead, she could not do so. Sorry.
Correct. That's right. She cannot rely upon her upon the rival wife's testimony. That was what we established back in Mishnah 4.
Right. So I thought here they should just let each wife have their own testimony based on that rule.
Right. So and in some ways that's what Rabbi Yehuda and Rabbi Shimon are doing. Although as the commentary points out, it's because they are not disputing his death that there's no reason to doubt it. But like I said as well, Rabbi Meir is trying to treat them not as two that are contradicting one another in the substance of the case, but as we would handle it in other cases, we are suspicious of witnesses that are not in agreement on some of the essential facts of the case, even if not the conclusion. And that is where Rabbi Meir is saying, not that we think that their testimony is in opposition to one another, but it is inconsistent enough because of the contradiction of their description, that inconsistency undermines their testimony just as it would in any other, any normal case of testimony. So, yeah, I think it's the question where we're getting caught up on is testifying against. It's not against, it's inconsistent with. Might be a better way of Rabbi Meir's position.
Right. I thought 4 was the inconsistent was one of the things they were adjudicating on. Obviously, one's dead, one's alive. That would be inconsistent.
But that's more than inconsistent. That's the material fact of the case. And that changes the status of the other. Whereas here, both of them agree that she should be considered a widow and my rival should be considered a widow. Neither one of them is disputing the status change that should take place for their rival.
Right. I thought we didn't get to the status change yet.
But we haven't gotten to the full discussion of it, but that is sort of one of the underlying issues of why this is not considered rival testimony, but merely inconsistent testimony. Right? The testimony of wife number 2 is not going to change one way or the other what happens to wife number 1 under most circumstances. And so Rabbi Meir is picking up on the inconsistency and saying, well, we can weigh their evidence, and if they're inconsistent, then maybe both of them are mistaken, as we would say in most other normal cases. And Rabbi Yehuda and Rabbi Shimon are saying, yeah, but they both agree on the point that actually matters with this issue, and in the matter that we actually are willing to listen to the women's testimony in this unique circumstance, and therefore they are free. let's go ahead and get the last part of Mishnah 5 out, and then we can see if there are any additional discussions on this testimony issue. If a witness says he died, and a witness says he did not die, or one woman says he died, and another woman says he did not die, this woman may not marry. So, as we mentioned a little bit in our discussion of Mishnah 4, if we have mutually contradictory witnesses who show up before the discussion has been resolved, and they're not actually the wife or one of the other people that we're not allowed to listen to under these cases, then we do delay any additional marriage until there becomes an unclouded balance of testimony. So in these cases, 1 versus 1, if no decision has been rendered, then the wife remains in a state of limbo, and it continues to be treated as though she were married to the man, and thus cannot remarry to anyone else. All right, shall we jump to Mishnah 6? All right. Hearing no objection, so moved. Mishnah number 6. In the case of a woman who went, she and her husband overseas, and she comes and says, my husband died, she may marry, and she may takes her marriage contract, the ketubah, based on her own testimony. So we have talked about this a lot so far, and this is just restating it as a start. And it remains prohibited for her rival wife, presumably who stayed home, to remarry, as a woman cannot testify on behalf of her rival wife, like we saw back in Mishnah 4. Now, this is going to tease out some of the implications of that. If the rival wife was an Israelite woman married to a priest, she may continue to partake of trumah, as she is not permitted to remarry, and therefore the presumption that her husband is still alive is maintained in relation to her. So really, when we say she's still married, we mean she is still married, says the Mishnah. And that means the perks of being married to a Kohen continue, even though we've let the other wife get remarried. So you've got one wife who is now a widow and perhaps remarrying, and we've got one wife who is still being treated as a wife and is still eating trumah. That would be absolutely prohibited to her if she were now a widow. But because the testimony of her rival cannot affect her status, she continues to be treated as the wife of the missing man.
So why the rival is forbidden to remarry?
The second, mean why the rival wife is forbidden to be remarried?
Yes.
Because the testimony of one wife cannot be used against the other wife. It cannot affect the other wife's status at all.
Yeah, but if she said that he died.
I got that. So back on Mishnah 4, in Mishnah 4, we were given a list, and we'll just do a quick flip back up there. There we are. And back in Mishnah 4, we were given a list that her mother-in-law, the daughter of her mother-in-law, her rival wife, the wife of her Yavam, and her husband's daughter, meaning her stepdaughter, cannot testify. Not for good, not for bad. They are just no information that they say will be relevant to that woman. And that's because, like we talked about, those relationships tend to have a lot of tension or outright hatred or animosity. And therefore, their testimony is considered from day one to not be usable, even in these cases where we are making extraordinary exceptions in order to free someone. So, and the Gemara goes, on to discuss various possibilities, meaning that the woman who went abroad and she comes back and says the husband died, she may be saying to herself, I'm going to say he's dead. Really, he's just in prison. And I'm going to get her in trouble because I won't get remarried because I'm sure that he's going to show up eventually. Or maybe I can even arrange for the family to get him out of prison. And I'll be the good wife who stayed loyal to him while he was away. And the other one's going to go off. She'll get remarried. She'll be forced to be separated from him when he returns. And her children will be considered mamzerim. And boy, I'm going to nail her because I'm going to say that she's dead, and no one's going to be able to argue with me because you have to listen to one person. And the rabbi said, yeah, probably best we don't listen to rival wives concerning each other, meaning the status of one can change and be different than the status of the other. Otherwise, we are setting ourselves up for all sorts of scheming that will end with great problems for the community. So that's why the rival wife is not allowed to remarry based off the testimony of the one who was with the husband at the time. It is always hard to be able to protect all of the eventualities. Like we've talked about a lot through chapter 15. On the one hand, we don't want to keep a woman married to a dead person because that's not fair to her. It's technically not fair to his estate. But on the other hand, we also don't want to allow a woman to get married to someone else when she's still married, because that second marriage is adultery, not marriage. And the children that come from it would be mamzerim. So trying to navigate this minefield to be able to come up with a good solution is hard. And in some cases, different people are going to not end up perhaps where we would hope they would be. But that is the nature of this doubt, where we can't see a clear picture, where we don't have perfect evidence. Yes, Eric.
Are they still mamzerim if you got permission from the court and then you get overturned by two witnesses or him actually showing up?
Unfortunately, yes. Now, does that mean that the court couldn't find a reason to exonerate and to find that they weren't mamzerim? You know, maybe he was only gone for 3 months and they're going to claim that she got pregnant from him before he went on the trip, and it just took an extra long time for conception to happen. Those types of exceptions can sometimes happen under the actual situations of a Beit Din. But provided enough time had passed that there was no possible way to excuse the pregnancy except as coming from the second husband, then yeah, they would be considered mamzerim because she was still married. As unfortunate as it was that the marriage, the second marriage that she had was with permission, it still was marriage that she was violating. There's no perfect solution to this. That is the problem. Well, I'm sorry, I should point out, there are perfect solutions to this. And just as a little bit of an aside, and maybe a taste for when we get to Masechet Gittin, when we talk about divorces, the husband can write a conditional get. He can write a document saying, if I'm not back in a year, then this should be considered your get from the moment of my departure, meaning retroactively. And if he writes it like that, and he doesn't come back in a year, then boom, she's divorced, she gets the ketubah, everything goes just fine. And if he shows up again and she's not remarried, they could always remarry her and the first husband. So there are ways to avoid the worst outcomes from this if you plan a little bit ahead and you recognize the danger of what could happen. Yes, sir.
Hey, Rabbi, I've seen one story. It was Chabad who claimed that's why the relationship with David and Bathsheba was not adultery.
Right.
That
Well,
would not.
Right. Chabad did not invent that story. That's the explanation that's given in the Midrash and the discussion in the Talmud, that David, King David, did not commit adultery because when Uriah died, it meant that his conditional get kicked in, and therefore she was divorced retroactively. So she was technically single at the time that she and David were together. So that absolutely gets David off the hook for full adultery. He's still on the hook for a lot of other bad behavior in that scenario, which is, of course, why the prophet Natan came and chewed him out on his misbehavior. But indeed, the tradition does try to at least exonerate him from the greater crime of adultery through that methodology, through that system.
Even though David was responsible for the death himself?
Well, David tried to be responsible for the death himself, but he wasn't. So that story is a masterwork of literature. When he tells Yoav to take Uriah and put him under the front, and then everyone else should retreat, leaving him to die. Yoav doesn't do that. He actually violates David's order. And instead, he puts him where the fighting is hardest, but the full unit is involved in the fighting, so that he doesn't leave him out there to die by himself. It's instead, he falls in the battle in the hardest part of the fighting. And David gets really mad at that because that means other soldiers got killed too. But that's part of the amazing way that whole section in the book of Samuel is crafted to give us that back and forth of how David, Yoav, Bathsheba, Uriah, and Natan are all dealing with this situation, and the machinations that are happening. Another time we'll study that in detail. Maybe sometime we'll go through that piece by piece, because it's really amazing, and the way the rabbis understand it adds many layers of depth to it. Let's go ahead though and finish up Mishnah number 6. So that statement about the Israelite wife who is still married even though her rival is divorced or is widowed, that is said as a statement of Rabbi Tarfon. Rabbi Akiva says this is not the way to spare someone from transgression, right? According to the opinion of Rabbi Tarfon, there was a concern that she might be eating truma unlawfully. And so Rabbi Akiva is like, whoa. You are creating the perfect situation to cause sin, to cause a transgression. And therefore, I don't think that's the right situation. There is no remedy for this situation, says Rabbi Akiva, unless it is prohibited for the rival wife to remarry, like we've said, as she cannot rely on the testimony of her rival wife. And it is also prohibited for her to partake of truma, lest the other woman was speaking the truth. In other words, the halacha is stringent on both counts, meaning the rival wife who wasn't there to witness the death is hit by stringencies from both sides. She is treated both like the widow, can't eat the truma, and like the wife, can't get remarried. And the halacha goes by Rabbi Tarfon. I'm just gonna, spoiler alert, Rabbi Akiva does not win the day in this. And instead, she is considered like she's still married, and she still is allowed to eat the truma because she is still considered like she's still married. And that idea of being hit from both directions is something that's going to continue in Mishnah 7, but we're going to have to save that for next week. But any questions about this finale from Mishnah number 6?
So the second wife, not the wife that went overseas with the husband, the second wife by Rabbi Akiva, she couldn't remarry, neither eating truma. But the first one, yes, she could divorce.
So no, the traveling wife can remarry, but cannot eat truma. No truma for the traveling wife. The stay-at-home wife, number 2, yes, she cannot get married, but she can eat truma because she's still considered to be his wife, because we have no evidence regarding the status that is relevant for her. So the traveler wife is treated as widowed in all ways, meaning she can remarry, she collects her ketubah, and she cannot eat truma anymore. And the stay-at-home wife, who has no testimony that she can use, she is considered married in all ways, meaning she cannot get remarried or married to any other man. She cannot collect her ketubah because she is not considered to be widowed, and she can still eat the truma because she is still considered to be part of his household.
Okay.
And Rabbi Akiva was a bit in disagreement on that, but Rabbi Akiva ultimately loses this argument. But as usual, you have to turn to the Gemara and the law codes to find the conclusion. I always think that's their way of to be continued in the Talmud.
So the third one can now remarry it, but not eating it truma.
Correct.
And the staying cannot remarry, but yes, can eat truma.
Correct.
So one positive, one negative for each.
Depending upon how you look at it, yes. The first one may have liked to have stayed with the house and eat truma, and the other one might have wanted to leave and could care less about the truma. But we don't make decisions based on what people want. We make decisions based on the evidence we have.
Yeah, and the truma is only in case that they were wives of priests.
Right. Now, it does still also matter that the second wife, if this was not a Kohen's family, the second wife would still be allowed to live in the husband's house and to enjoy his estate and be kept by the estate. So they can't kick her out because she is still his wife. So she does get the benefit of being part of his household, even if he's not a Kohen. It's just not as obvious a benefit like Truma, where there's such a black and white line between who can have it and who cannot. That's why they use Truma, because if Truma is okay, then anything else would be okay as well.
Yeah.
All right. Thank you all very much. And we will continue with Mishnah number 7 and a similar topic next Wednesday.
Thank you, Rabbi.
Thanks very
Take
much.
care, everyone, and be well.